termination, again, when you look at termination, okay, termination, you should have the ability to terminate on mutual agreements. You should have the ability in your contract to terminate because there is a material breach. Again, set the material breach properly, because sometimes material breach is a very wide concept. There is no definition, and you must derive it based on what you feel is material for your company. So in this, in fact, we in fact are dealing with one of these clients where the client has invested, my client has invested 25% in a joint venture, and the 75% shareholder wants to go public, etc., and wants to do an IPO and things like that. But my client is not very happy and wants to exit. Now, exit is not possible because DOT has given certain regulations under which your investor has to be in India, your foreign investor, for X amount of years. And though we've not completed those X number of years and we want to exit, we try to make an appeal to the government saying that, we want to exit, we are not happy, we don't even want our value back. So we've put millions into this business, we want to actually exit at only 1 rupee, so just let us exit. But the government is not agreeing to this kind of a termination, and we are still fixed with the regulators, going back and forth with the regulatory authorities requiring the exit. So when you're doing a termination, if there are licenses which are going to permit, which are going to in fact prohibit you rather from exiting, then those to identify those kind of things and keep those in clauses. So you at least, if I can't exit from the venture, I should be having the ability to control certain aspects. Though I'm only controlling 25%, then you should, for certain reserved matters, take my approval, because by law, I'm locked in. So I'm locked in by the agreement, I'm locked in by law. So when you don't draft correctly initially, at the time of exit, these stupid things come into picture, and then it becomes very difficult. So make sure that your termination relates to your business also. And as a trick, always identify the licenses which are connected to the business, and first check what are those clauses, whether there will be a termination possible after 2 years, or should the lock-in be shorter, longer, things like that. Termination, hundreds of reasons. But these are some of the typically used reasons for termination. So you obviously have death of parties, insolvency, change of control, misrepresentation, and warranties. Here, these again, dissolution, non-performance. Non-performance, again, many times there will be somewhere where there will be a dispute over non-performance. So instead of just, automatically providing for termination, if you are the service provider, then make sure that your document has a remedy period for non-performance, and you are able to have some time. It shouldn't be that you are expected to do everything on time and then otherwise I'm going to terminate you. So if you are representing the service provider, then try to put a remedy period that, if there is a non-performance, then within this much time, you should be able to perform it, things like that, and it doesn't become an automatic termination. Change of law, of course, always keep it. This change of law and, things like that here, this has become very important in terms of now this COVID pandemic. All of us saw that contracts, people were not able to deliver contracts on time over the last 2-3 years, and a lot of contracts people had to terminate. People were not able to meet their obligations. So keep a change of law where, because the government suddenly declared COVID as a pandemic, things happened and parties were not able to. So, you should have an open mind when you're drafting your termination clauses to include things like change of law, which make the contract ineffective. Then what do? You can't say that, oh, I suffered a loss, so you pay me. No, if you're properly drafted, you will not have these kind of issues. Revocation of government approvals, mutual consent, of course, should be there. And conditions precedent, deadlock, things like that. So these are very commonly used termination grounds where the agreement will terminate. Always try to keep a remedy period, like I told you, and also give flexibility to the parties to mutually discuss certain things if, there is something that is not being done properly. Give an arbitration, connect your termination to a remedial or a mediator, things like that, and then you can kind of either say that because none of this happened, we want to terminate. Or of course, if you are in a stronger position where you call the shots, then you make sure that your contract is drafted in such a way that you have the right to terminate the minute you want to. Termination, the way of good drafting is that you give, as I told you, a notice, you give a remedy period, you do all those things. And if it's not possible, then you kind of say that we want to terminate the agreement. So here I have given you a few examples of termination. Where you can, see like a 15-day prior notice should be given, or termination because of material breach of an agreement by 30 days notice, or both the landlord has a right to terminate, or the lease contract can be terminated by either parties by giving them a 30 days notice. Always good to have some, period, and not just immediately terminate, because then it might affect your business. So you have to see which side you're representing and accordingly keep your termination clauses in mind. And of course, if you're terminating, there should be some consequences. So you should have like non-solicitation, confidential information not being leaked, returning all the stuff that you've taken, or if there is a patent or something that the employer has created and he's terminating the employment, then the employee is supposed to return all of that. And damages, if there is like a damage that has been done in a leased premises, then the consequences is that when you terminate, you're supposed to I will either adjust it in my security deposit amount, or you are supposed to compensate me, things like that. So these are just examples of how you can draft a termination clause. On termination, all the licenses, etc., terminate, things, the obligations which are completed. So just like 1 or 2 examples for you guys to kind of understand a typical termination, or what should be there in a termination. Post termination, again, we've already covered. My last clause for today is the survival clause. Now, survival clause, people think it's a boilerplate. It is not very important, but I'll tell you, survival clause is very important, because whenever your agreement terminates and you still want to claim benefits under the agreement, or you still want the ability to sue, the party wronging you under the agreement, you should have a survival clause. So even if the agreement comes to an end, your certain clauses continue to apply for X period of time. So many times, when there's service providing agreements, service contracts, etc., your agreement may, terminate. But because you have provided services and you have privy to so much information about the company, if you're a certifying authority and your service scope is like certifying documents or issuing, certificates, ISO standard certificates, you would want to make sure that even if my contract is terminated, my party, my certifying authority has all this important information about my business, and confidentiality continues even for 2 years after that. So, or there is a employee requirement or a non-compete which can be enforced. So for 2 years, there will be a non-compete. So certain clauses will survive the termination of the agreement. That is kind of a gist of what the survival should do and what it can and cannot do. Here, I have given you like a typical example, saying that in this, the first example, I have said that confidentiality is something that will survive because their confidentiality was important. If there are a couple of clauses, like there is a confidentiality, no compete, non-solicitation, governing law, all these which you want them, then you put all those clauses as well. So this example here, where you see the clauses, this is a very, very typical way of putting a termination, a survival clause, where you put all your articles. This is the right way of drafting it. And this is a shorter version of a survival. but I would tell you to always try to put in as many clauses as possible, so that later, if there is any dispute, you can go back and, open up those clauses and revisit those issues. So therefore, in my opinion, survival is an important clause, and don't treat it as a boilerplate and copy paste it. See what more you want and add all those clauses as surviving clauses.